Welcome to Law&Crime Report, everybody. I'm Jesse Weber, and thanks for joining us. We're going to start with Britney Spears' conservatorship. This is a very hot-button issue. It's straight off of the documentary Framing Britney Spears, which has really ignited the conversation. A judge has ruled that Spears' father, Jamie Spears, must now share his conservatorship with Bessemer Trust Company. This is something that Jamie had objected to. And when we talk about conservatorship, what we're really talking about is the control over Britney's finances, other aspects of her life. And this has been a very messy case where the pop star didn't want her father as a conservator. It ignited the Free Britney movement. In fact, if we go to take a look at what happened during this conservatorship hearing, look what was going on outside. A lot of activists outside this courthouse in LA. Take a look.
Britney, has been going on since the May of 2018. There's a podcast, Britney's Grand. They dropped an episode that had a voicemail on it. A lawyer was talking about Britney being involuntarily committed. And ever since then, we've come out and supported Britney because Britney is signaling that she wants to change in the
It's pretty incredible. It's grown a lot over the last few years. There's people from all over the world. Usually without COVID, people would be flying out here from different states. People meet every single week to organize rallies and try to sign petitions, and it's become a lot bigger. It's actually about conservatorship abuse in general now, so people are really trying to not only help Britney, but use this as basically kind of a flagship to show the corrupt system in general.
Are you going to be there for every hearing that you could possibly be at?
Yes, I mean, pending, obviously COVID's kind of crazy in LA, but usually we try to make it to all of them.
Mm-hmm. And what are you hoping out of this?
I think we're hoping, that Britney gets her autonomy and gets control over the money that she's earned.
Okay, let's break it down. Joining me are Law and Crime legal analyst Gene Rossi and trial attorney Catherine Smith. It's good to see you both. Gene, I'd like to start with you. Let's talk about the legal aspect of this. So what does this mean now that we have Britney Spears' father and this company now seeming to control the conservatorship together? How does this work? What does it mean?
Well, it sounds like the judge is taking baby steps and taking the power from the father who had exclusive power, and now there's someone who's a co-equal with him. And I assume that they have to have a unanimous vote on the conduct of controlling the assets and dissipating the assets. But I have to say this. Britney Spears is an adult. And as a father who had a daughter in the 90s and listened to her music constantly on the way to soccer games and all that, I am just appalled that the father doesn't voluntarily get out of her life and allow her to run her estate. But it's probably a joint, unanimous decision arrangement so that the father doesn't have full power. Baby steps.
Well, let's talk about that, Katie. Could we ever see a situation where Britney is free, that she no longer has a conservatorship? And how would that work? Because if we can't forget, this all stemmed from her public meltdown years ago, right? And so what would she need to do in order to manage her own affairs?
Yes, Jesse, Britney hopefully one day will be free of all these restrictions. These findings are not permanent. And we believe that it traces back from that initial meltdown. But from my understanding of the law, that in and of itself would not be enough to keep this conservatorship for so long. So there must have been additional showings to the court because this is a very restrictive thing to put in place on someone's life. And I completely agree with Gene. Britney's father should back out of this. It has the appearance of being unfair. She wants him to back out. It's very easy if there needs to be a conservatorship to have a third party so that there's no appearance of any impropriety.
And what advantages would Jamie Spears have of being in control of the conservatorship? If I'm stepping into this, and I've heard reports that he does want to step into it, he might step out of it, he might not want to do it anymore. What's the advantage for him, Gene, of continuing this? What's the advantage of Bessemer Company having control of this? How does it work exactly for them?
Well, the advantage for the father is I assume he loves his daughter very much, and he just wants to do what's best for her. The downside is, and it's what Katie just mentioned, is you don't want the father running the daughter's life. You want someone, a third party, a detached person. You want sort of a blind conservatorship. That way, you don't get the father with any conflicts. He may have side deals. He may get, there's just opportunity for malfeasance. Having an unattached third party is the best way to run a trust, to run an estate. The father should just back off and get out of there.
And Katie, real quick, so we understand, the judge in this really rejected a bunch of arguments from Jamie Spears' attorney. If you can explain it to us, what were those arguments and why were they rejected? Katie, we still have you there?
Yes, I'm here. Sorry
I
about
think
that.
we might have
So
lost
the
Katie.
initial,
Oh, Katie, yeah. So
the initial
again, yeah.
The initial concern that that Jamie had, of course, was, well, Britney had the concern that Jamie was going to be dealing with more other third-party places to get recommendation other than Bessemer Trust. And Jamie, of course, wants to hold on to this decision-making power. And luckily, the arguments that he posited to the court were such that the court said, wait, hold on. We're not going to cede more power to you. We are going to allocate some of these responsibilities to Bessemer Trust so that they can structure the assets and make sure that they do investment decisions for the fund. So that's my understanding of basically the win for Britney.
Well, this whole conversation is not going to stop here, and the legal aspect's not going to stop here, because she has hearings March 12th, April 27th to continue this. Again, she herself, Britney Spears, hasn't really made public appearances on this. It'll be curious to see if we see more activists outside the courtroom for these hearings. We'll wait and see, because it's a conversation that people still are highly invested in. Now, I do want to switch gears to a very high-profile case, because tensions were running quite high during a hearing for Kyle Rittenhouse. Now, a judge has agreed to not increase Rittenhouse's bond nor send him to jail after the prosecution argued that he failed to keep the court aware of his current address. Rittenhouse, if you recall, is the 18-year-old who's accused of murdering two people during the racially charged protests in Kenosha, Wisconsin, after the police shooting of Jacob Blake. In order to give everybody a sense of what we're talking about here, let's take a listen to the father of one of the slain victims, and you're going to hear from a surviving victim of the shooting as well. Take a look.
Well, from the beginning, from the moment he became a killer, he thought he was above the law. And he has no remorse for what he's done. And he is enjoying this media circus and the support from these hate groups and militia members that have posted his bond. Okay? It's not like his mom and dad put up the family house to get him out. He has nothing to lose if he runs. He has nothing to lose. Matter of fact, he's probably going to spend the rest of his life in prison if there's justice in that town of Kenosha. He should be remanded to custody. I don't know about what the DA was supposed to file, but this kid, we don't know where he is. You don't know where he lives. Nobody in that court knows where he lives. And if it's supposed to be a secret, if he's got all this back end, what is he afraid of? Got all these people supporting him. You know, why does he need to be in a safe house? His bond should be $4 million, like I said in the beginning. It should have been something that he can't just raise on his own. You know, and the people that did raise his money, I guess they're not around anymore. But we lost a son. His mom and I lost our son. And how would you feel if the killer of your son is just able to walk free and make videos in bars and live it up? You know, whatever the statutes are, they must be wrong, because this guy can just go and do whatever he wants after he killed our son. Our son didn't get to spend Thanksgiving with us, but Rittenhouse did. He got to spend all kinds of time at the bar, live it up, making videos with his white supremacist friends, singing videos with a shirt that says free as F. You're not going to be free as F. Justice is going to be served to you.
Again, my name is Gage Grosskreutz. I'd like to keep this brief. First off, I'd like to echo the concerns and grievances that the DA has provided, as well as the clearly emotional issues that Mr. Huber has just stated. Again, I would like to restate that it is, in my opinion, that Mr. Rittenhouse has shown a pattern of lack of remorse during this bond time before trial, and I would also recommend that the bail be raised to $4 million.
Okay, Gene, I start with you. You heard
Yep.
some really compelling arguments there. People were surprised that Kyle Rittenhouse is still out. No change in the bail here. What's going on?
Well, I think this is a very generous judge, and Judge Schrader said that bail is a right. So that's his view on bail, that you're not convicted while you're on bond or bail, that you have the presumption of innocence. I will say this: I'm looking at this record here. He's been accused of 2 counts of murder and 1 count of attempted murder. And for the life of me, I do not know why he is not, 1, under house arrest, and 2, with electronic monitoring. I have a client who's been under both for 2 years, 2.5 years, and it's a much lesser charge, of course. But for this type of charge, 2 deaths and attempted murder, he should be under house arrest, electronic monitoring, and he can't go to bars. He can't get intoxicated. He can't flash the racist signs, and tell that kid he better fess up or he's going to jail. The judge was very lenient on this kid, very lenient.
Yeah, Katie, I'd like to get you into the conversation on this because the judge said, look, he doesn't know where international business defendants are located. They're allowed to leave the country. They can do so as they please. He said that the border county of Kenosha frequently allows defendants to cross into Illinois unless a judge places a restriction, which is not the case here. Again, you heard Gene say very lenient. What's your thought process on why the judge did this? And he did make a point to say, look, I know this is a very high emotion case. This is a sad case, a tragic case. You're dealing again with a guy who's accused of double murder,
Right.
an attempted murder. What's the rationale here, Katie?
I agree with Gene. I think to me, it feels like that the judge is bending over backwards to provide for allowances for him. We have lesser cases where people are given higher restrictions. And while I agree in principle that bail is a right, bail is supposed to serve a specific function, right? It's not supposed to be punitive. It's not supposed to punish. It's supposed to ensure that you're going to come back. And I believe it was the victim's father who said, because the bail was posted by other people, that he doesn't have any real property attached to it, no consequences, he could run. He could run anytime. And that means that bail isn't fulfilling its purpose here. So I think at the very least, you can jack up that bail, try to get him to have some of his own assets so that the purpose of the bail is going to be fulfilled, or at least get some sort of ankle monitoring. These concerns are very real.
Well, there is a lot to break down from this hearing, including the fact that the judge said the DA in this case doesn't have a right, is not permitted to know where Rittenhouse lives, his current address. If the DA wants to know that, he's going to have to speak to the sheriff's office. We're going to get into that. We're going to get into more details of the arguments presented during this hearing, but we do have to take a quick break. So when we come back, it's going to be about Kyle Rittenhouse. Stay tuned. And welcome back, everybody. We're still continuing the conversation on Kyle Rittenhouse, the 18-year-old accused of killing 2 people and injuring a third in those protests after the shooting of Jacob Blake. Really high-profile case. And what we're specifically talking about is this hearing where the judge had an opportunity to ultimately send Kyle Rittenhouse back to jail, or actually revoke his bond. Didn't work that way, and ultimately said that what the prosecution had argued, there was this intentional point of Kyle Rittenhouse to deliberately change his address. That was just a kind of a systematic error. Just fix it up, not a big deal. And that's really what we're talking about here. But I want to go back to the attorney for more of these speaking yesterday for one of the victims and the estate of one of the victims, just really presenting a strong argument. Take a look.
30 days ago, the court, not this court, but there's another Kenosha County case involving also a double homicide where a male of color was given a $2.5 million bond. 2.5 million. And we ask that the court also take that in consideration, since Mr. Richards found it necessary to bring up something that was not relevant.
Well, I will tell you that I am not going to decide anything in this case or any other on the basis of the color of anybody's skin, period. There was a decision made, in, I think it was 1896, Plessy versus Ferguson, where a decision was made on the basis of the color of someone's skin. A man who was, by the way, was 1/8 African-American descent. And it was a test case. And the Supreme Court of the United States, which has a spotted history on these issues, I'll digress enough to talk about Roger Brooke Tawney saying that a black man could never be a citizen of the United States in 1854, which brought on the Civil War, and Plessy versus Ferguson, where Justice John Marshall Harlan issued a stirring dissent critical of the 8-to-1 vote of the court to permit segregation in by state law in transportation, and said what an outrage it was and what harm it would cause to the country. And we suffered for a long time because of that, because decisions were permitted to be made on the basis of that. I don't know anything about that other case. I don't know who the judge was. I didn't set this bond, and I didn't set that bond. And so I'm not going to comment at all about that, other than to say this case came to me. It had an initial bond of $2 million set by Judge Wagner, who may be the same judge who set the bond you're talking about. I don't know. It was reset by Judge Keating at first appearance, and what's been reported to me now, he was not put under condition of living at a specific address. That could have been done. The district attorney apparently was aware of what he now refers to as flying the coop. Was aware of that situation back then, and he didn't ask for conditions on place of abode, and Judge Keating didn't order it. So there's no change in circumstance there.
Okay, Gene, now the judge here did fault Rittenhouse for not leaving the correct address, but he did say this is something that could be, amended, and that and this was the part that I really want to ask you about, is that he said his address would remain secret, can't be made public. And that also includes the DA. The DA wanted to know the current address of Rittenhouse. Judge said no. Judge said, if you really need it, go to the sheriff's office. What do you make of that?
Well, when I was a prosecutor for almost 30 years, I never really cared about where the defendant lived, unless there was some public safety reason. I always trusted the probation office, the supervising officials who work for the court, that if they know where he lives, and they tell me they know where he lives, that's fine with me. I'm not going to send out cops to surveil the house, but I got to defend Mr. Rittenhouse here a little bit, all right? I do think he got off lenient. And by the way, I thought the judge was lenient, and he went off at a tangent on Dred Scott and Plessy versus Ferguson. I don't know what he was talking about there. But here's the nub of the issue. You have to know where a person lives. And if he's moving around to a hotel or another home because of the fear of getting hurt or harmed, I'm going to cut that person a break a little bit. And what I read in the record is Mr. Rittenhouse is getting harassed, understandably, and he's moving to a hotel or he's moving to a friend or a family member. His big mistake is he didn't make it clear to the probation officer that he's going to another location. That, to me, is a slap on the wrist. Tell the kid, don't do it again. You have to let us know where you are living. And that's why I think house arrest, electronic monitoring are appropriate. And tell that kid, if you go to a bar or you go to any place where you're flashing racist symbols and wearing shirts like that, you're going to be behind bars in a New York minute.
So, Katie, let's talk about it. Do you think that this is a situation where Rittenhouse is basically, smacking the court in the face because, again, there were all these images of him at a bar, with that shirt. And again, this idea of changing his address. You heard the argument from one of the attorneys basically saying this is an issue of race, that if there was a defendant of color, he would not be treated, or she would not be treated the same way as Rittenhouse. Your thoughts?
I think that there are a couple ways to look at this, as there are with most issues, right? I mean, the bottom line is, and this is sort of what the court was addressing, they said this was an initial request that was made from a different judge. And at that time, both parties had the opportunity to argue for and against bail restrictions. And at the time, the DA's office did not ask for any other restrictions, and it wasn't ordered. And so the judge here is saying, listen, there's no new circumstances here. He's showed up for every hearing. We don't see that this is a really big deal. He needs to update his address. The problem that I have, though, is that he's flouting these court's orders and going out in public and making it seem like this is a joke. And that's a really bad optics for a case that has this level of seriousness. And it also, I'm sure, makes the DA's office concerned, right? They have a right to know where he lives. I don't understand how letting them know where he lives would be a security concern. But I can understand that he has security concerns. So I think at the end of the day, he should be pushing back a little less on this, update his address with the court in the DA's office, and stay out of the public eye a little bit until this can be properly heard in court.
And here's the judge himself denying that motion to revoke the bail.
The last hearing, which was the one, which was the return notice, he was there at Mr. Richards' office. So I'm assuming he came from wherever he was to Racine to attend that meeting, and he's here today. So I'm going to deny the motions.
I hope you're not suggesting that sharing this information with our office is somehow going to lead to further violence, because we would not be in any way contributing to that. But our obligation is to help monitor the defendant's bond conditions, and without knowing where he's at, that becomes very difficult. If I'm to file a charge of felony bail jumping, for example, for the defendant violating his bond, and I don't know where he's at, that makes it pretty difficult. And if the court has placed the burden,
you call the court
and
call the court,
criticize me for not doing so in the past, then I feel like I need to have this information. And certainly no one on this Zoom call needs to be reminded of the events of 6 months ago. We have the loved ones of two deceased and a victim who was shot in the arm by the defendant that night. So
please don't use the term victim.
The Mr. Grosskreutz was shot in the
Any
arm.
Witness.
Your Honor, if Mr. Binger wants my client,
what's that?
If Mr. Binger wants my client to appear on what he's going to do next, which is issue a felony bail jumping, send it to my office. He'll be in court the next day. This posturing is not serving any purpose at this point. The court has ruled.
Your Honor, it's not posturing. This is standard procedure in all criminal cases that everybody knows where the defendant is. This is highly unusual for this to be withheld under seal. The court has ruled that it can be sealed from the public, but we are not the public. We are the prosecuting agency. We are the prosecutors on this case, and we have a very important right to know this information as the prosecuting agency in Kenosha County. And I have never heard of a situation where this information has been withheld from our office. The Sheriff's Department, you're right, is a law enforcement agency, but we work with them, and to withhold them from giving to us, the court not giving it from us, to cut us out of that information is not appropriate here. Our office is headed up by the elected DA, the chief law enforcement officer in this community. This is a murder case, and we are entitled to this information, Your Honor. We have never been denied this information in any case that I've ever heard of. And if the court is aware of a case in its history where you've not shared this information with us, I would appreciate you sharing that with us, letting me know what case that was, because this is highly irregular. We have a right to know this. I would argue the public has a right to know it as well. I understand the court's ruling from sealing it from the public, but our office has a responsibility to enforce the laws, enforce the bond here, to file bail jumping charges if there's a violation of that, and we cannot do our job without this information.
Okay, Gene, I'm going to go back to you on this. Now we're hearing this back and forth between the judge. A little contentious there. Again, what do you make of what we just saw?
Okay. Mr. Binger is really pushing the edges of the envelope. I'm not sure he is correct that the prosecutor has the right to know where the person lives. The sheriff's office does, the court does, the probation officer who supervises him on bail, they have a right. But the prosecutor, I don't know if he has the right. And it gets to what I said practically. He's wrong. You can prove a jumping bail violation without knowing exactly where he is, because the probation officer, the sheriff will say he was supposed to be at X home at 11 o'clock at night. He wasn't there. They would be your evidence. Here's where he lost credibility in my book. Number one, he's interrupting the judge. But number two, he said the public has a right to know where he lives. That is absolutely wrong. In a case where a person is being harassed and has safety concerns, and Mr. Rittenhouse has safety concerns, people want to kill him. They want to kill him. And he's facing serious charges. The public doesn't have a right to know, because a court can say, to protect the defendant's safety while on bail, a court has broad discretion to say, I'm going to seal it and only provide it to the sheriff, to the probation office, and to the court. He has the right to do that. It's not appealable. It's appealable, but it's going to be a loser.
Well, I'll tell you, all this just makes me think what a trial would actually look like, and trying to get a jury that hasn't heard anything about this or hasn't made up their mind. It's a separate issue for a separate day, and maybe we'll get into it at another point. But we're going to take a break. When we come back, we have some new details in the Jeffrey Epstein saga that we have to go through. We'll be right back.
Yes, contemporaneous with the arrest of Epstein at Teterboro Airport, agents executed a search warrant on his mansion in New York City and recovered and seized, and that was a search pursuant to a valid warrant. Agents seized evidence, including nude photographs of what appeared to be underage girls.
Welcome back, everybody. So that was William Sweeney from the FBI talking about evidence that was collected in the case of Jeffrey Epstein, the sex offender and financier who was accused of abusing underage girls, but who was found dead in his jail cell. Well, now we have some new disturbing details to report to you, as if this case couldn't get any worse, because the AG in the Virgin Islands, who's actually pursuing a civil racketeering case, claims that Epstein forced marriages of his victims in order to hide assets and secure immigration status. Now the co-executors of Epstein's estate have been added as defendants to this action, and a lawyer for Epstein's estate has rejected the allegations, and this all stems from alleged abuse that occurred at Epstein's island, the Little St. James Island. So there's a lot to break down here. I want to get right into it. Katie, what's going on here? What is he, well, what is the accusation? What are the allegations here, and what was the goal?
So it appears, and as you said, Jesse, I mean, could this get any worse? And every piece of information that comes out, I'm never surprised, because it always gets worse. And this is worse in the sense that it shows so much planning, right? The allegation is that he had the victims marry each other and other people for immigration purposes. And it doesn't surprise me. He's gone through such deliberate lengths to inflict all sorts of harm of varying degrees on these victims. And this was yet another way to capitalize on control of these individuals. So it's terrible, but sadly, I am not surprised.
Okay, Gene, but how does this change the case now? How does this change the case in the Virgin Islands? What are you looking out for?
Well, it's all about money and taxes, and it seems like the Virgin Islands has tax liens that the Epstein estate or Epstein had not paid because money's driving this civil lawsuit. But here's the thing. They're arguing that the estate is a criminal enterprise and that the co-executors, the two individuals that were joined in the amended complaint, are part of that criminal enterprise. This is serious stuff, because the estate's trying to sell assets to either gather money for the estate for distribution and or to pay into some type of victim compensation fund. So the Attorney General of the Virgin Islands is actually, in a way, preventing the estate from obtaining some money that may go to victims. That's what I understand. but also the estate's trying to gather money for distribution because Jeffrey Epstein obviously is deceased.
And Gene, let me follow up with you on that, right? This is a
Yeah.
civil racketeering case.
Yes.
Are you saying criminal charges could flow from this?
Yes, because a civil RICO is everything that a criminal RICO is, except the burden of proof is beyond a reasonable doubt. I'm sorry, preponderance, 51%. So if they have the elements for a civil RICO, 51%, I I find it hard to believe they can't get up a little bit higher to beyond a reasonable doubt, which is 90% certainty, not beyond all possible doubt. So my view is if the attorney general has a civil RICO, they could be coming close to criminal charges, especially if they've added those two co-executors of the estate. So if I were those folks, those two guys or gals, I would be getting lawyers because you have criminal exposure. And here's the thing about a civil RICO. You can do discovery. It's a civil case. So if they are being deposed and there's written interrogatories, requests for admissions, and all that stuff, they may have to claim the Fifth Amendment.
And maybe that's what will ultimately happen here, because this is a big development that, it just gets worse and worse, and you're hearing more of what he was up to when he was alive, which is seemingly all not good things. Okay, we're going to switch gears here, because there's also a big development that we want to talk about in case you haven't heard, because we're learning new things in the case of Derek Chauvin, the former officer who's facing murder and manslaughter charges after that viral video showed him pressing his knee on the back of George Floyd for almost 9 minutes. Well, apparently, Chauvin was going to plead guilty to third-degree murder right after this happened, but former AG Bill Barr wouldn't let it happen. He said no. Reporting suggests that this was a bad deal, and they felt that Chauvin would have gotten reportedly 10 years in prison. Barr reportedly thought that this was going to be too rushed, that the punishment was too lenient, and this is interesting. So, Katie, I turn to you. This is an interesting development. What do you think that was the right decision? Because we would have had a conclusion, but I don't know if it would have been the conclusion that everybody was hoping for.
Right, Jesse. And there is a sense. So first of all, just because people have plea discussions doesn't mean that it always happens or that it even has to happen. So this oftentimes earlier in cases there are discussions about these things. So it's not on balance terribly bizarre that it wouldn't settle early like this, especially when there are major public implications to this. It would look really bad and it would feel bad from the public perspective to have this closed out and not really get to the bottom of everything. I think that there is a major benefit to airing this publicly so that we could really understand what happened, the failings institutionally, as well as the individual failings. And I think it would have felt like a rush to judgment and a bit of a cover up because then the case wouldn't have really proceeded in the same type of manner and we wouldn't have been able to get as much information. So it is interesting, but I'm actually glad that he did not settle earlier.
Well, here's the thing, Katie, I'll stick with you for one more second. We are not on the jury, right? We've learned this information. You hope the jury, whoever the jury will ultimately be, will not know this information. The idea that we know he was willing to take a deal, does that mean that he doesn't feel too confident in his innocence?
That's true, Jesse. And by the way, this is something that a jury would not get to know. Settlement or plea discussions are not up for the jury to take into consideration for exactly what you're talking about. This improper inference that just because you want to take a deal means that you did it, because those are two totally different things. But in this case, it sure makes you feel like he had some knowledge of what he did, A, and B, knew that he was going to be facing a really tough time moving forward. So I think it shows that he had a clear understanding of exactly how hard this road is going to be for him, and that he might obviously, if he goes forward with this, get a lot more than 10 years.
Well, Gene, I'm going to turn it to you because I know you have not been the biggest fan of former AG Bill Barr. So I give you an opportunity to talk about what you think about this report.
This is going to be a shocker, a miracle. I'm going to praise Bill Barr's decision. Okay, you are right. I'm not a big fan of him, but I think Attorney General Bill Barr did the right thing here. And here's why. I think the article that I've read by Pete Williams and Janelle Griffin is a little confusing, unintentionally misleading. What I think happened here is this. Chauvin's attorneys went to the Justice Department and said, listen, if the Justice Department closes or does not open a civil rights investigation, criminal, which is a tough row to hoe, if you don't open that, I will go into Minneapolis State Court. I will eat a third-degree murder charge and serve at least 10 years. Okay? That's what happened here. The Department of Justice does not prosecute state murder charges unless it's on federal property. So that's what happened. You stop feds from investigating me for civil rights, and I'll go into state court and I'll eat third-degree murder. And Bill Barr did the right thing because he didn't have all the evidence, he didn't have all the facts. And the other thing is this, he did not want to put his thumb on the scale of justice here and take away the state prosecutor's right to seek justice for the victim, Mr. Floyd's family at all. So this was the right call by Bill Barr. And you're right, I'm not a big fan of him.
I'm shocked. I hear it was the right call by Bill Barr coming out of Gene Rossi's mouth. The first time that I've heard that, and it happened here on Law&Crime. So stranger things have happened, but I totally get it. I know. I'm just teasing you. Okay, we will focus a lot on the Derek Chauvin cases. His trial comes up, but we're going to take a break. When we come back, we're going back to a case that we talked about a while ago. Remember that viral video of those two officers from Buffalo pushing down an elderly man to the sidewalk? We have an update for you in that case. We'll be right back. And welcome back, everybody. So charges have been dismissed against those two Buffalo police officers who were caught on viral video shoving a protester to the ground, cracking his skull. A grand jury dismissed the assault charges against officers Robert McCabe and Aaron Torgalski. And we're going to start with a video of this. I warn you, it's very disturbing, but you're going to see the push of 75-year-old Martin Gugino. Take a look.
He is bleeding! He's out of his ear! He's bleeding out of his ear! He's bleeding out of his ear! Get a medic! What the fuck you walking up on me? I'm gonna grab! Get the fuck away! Call the cops! Y'all don't want this shit! Back up! Get off the steps, let's go, get back! Get back!
Better get an ambulance for him.
We have EMT on scene.
Okay, Katie, I bring it to you. Why were the charges dropped?
Man, so this is a tough one because, as we know, officers are allowed to have wide discretion in the execution of their duties, but they're not allowed to intentionally injure someone for really no legitimate basis. I think the grand jury did not return against them because they didn't find intent. I imagine that they believe that he intentionally pushed him, but they didn't intend to injure him in that manner, and they were trying to get him away from them. I guarantee they said that he was crowding them and preventing them from doing their duties, like obstruction of governmental administration, and he was out after curfew. And so it could just be that the grand jury didn't think it was enough for intent and felony charges, but they still can be charged for misdemeanors. So I don't think that this is the end of the road yet, Jesse.
Well, that's an interesting point to make there. And Gene, I turn it to you. Yeah. One of the reasons I'm curious, do you think, is that, look, this occurred literally in the height of when there was a real big conversation about police brutality. Everything was happening with these police-involved shootings and killings, and it was a really, really high emotions. Gene, do you think since that time it's kind of cooled off in a bit? And do you think that contributed to what we saw in the dismissal of those charges? And I'm not saying one way or another whether these officers should be charged, but I'm curious if that contributed to that in any way.
All right. From what I understand, DA John Flynn presented these charges recently to the grand jury. You're right. The emotion probably has dissipated, but I get the feeling that John Flynn wanted the felony charges. That's my gut. And I got to compare him to the Attorney General of Missouri, Dan Cameron, who lied to the public about presenting charges, Breonna Taylor case. I think Flynn wanted these felony charges. The jury wasn't buying it. And what I'd like to know is, did these two officers testify in the grand jury? We don't know that. There could have just been a summary of their interviews or their statements. But what I think happened here is the grand jury looked at the video. I'm sure they played the video. And probably what Katie said, he didn't intend to hurt Mr. Gordino, I think his name is, but he did intend to push him. But the problem is Mr. Gordino was in the hospital for 30 days with a fractured skull, and he's 75. So I think the jury was very, I hate to use this word again, very lenient and cut them a break. And Katie's right. They may face misdemeanor charges, but more important, they may face civil charges because the Supreme Court recently sliced away on qualified immunity. So there could be a civil action against those two officers or the one officer who pushed them down.
And maybe a lawsuit filed by Gugino against these officers,
Yes.
something that I believe he or his representative were asked about relatively recently, and they didn't reply. So we'll keep an eye out for what happens next. But, you know, we're talking about this. The law seems to not care how old you are, because we talk about an elderly gentleman. Let's talk about a 95-year-old man who has been charged with murder after allegedly killing a worker at a assisted living facility. Can't make this up. Man's name is OK Payne, and he's accused of killing Ricardo Medina Rojas after Payne allegedly believed that the workers were drugging him and stealing his money. He allegedly shot the man in the lobby of the facility and then threatened threatened others with the weapon that he had. Payne has not entered a plea, and a GoFundMe page has been set up for Medina Rojas's family. So it's a really sad case, Katie, but my gosh, what is going on here? What do you make of this?
It's really sad. I mean, it's sad because whenever you hear about something like this, to me, I initially think, how could this have been prevented, right? How did this guy have a gun in an assisted living facility? As you know, a lot of times when people have dementia, they can obviously get confused, and sometimes people get more violent. And so it is not impossible in any way that this could happen. So I think it's so bizarre that he had access to a weapon there, but also it's going to be difficult to prosecute because I imagine it's going to be hard to show the requisite intent if he does have dementia, that he understood and appreciated his actions. So I think we have a lot more to expect forward on this one.
Yeah, Gene, we have a 95-year-old man, possible mental health issues. We do have a deceased a man whose family no longer has him. And so how do prosecutors pursue this case, and what is their best avenue?
Well, they pursue it very delicately. They have to charge him with murder. They have to. I don't care if he's 105. But what's going to happen at the trial is he's in a wheelchair. He'll probably testify, maybe, but they'll have an expert, Katie mentioned it, on dementia. And I got to tell you, this looks like a hung jury to me because, you know, of his age, his frailty. You know, he just lost it. He just lost it. He had demons that thought where he was thinking that they were stealing his money. And he just said, I'm going to take the law into my own hands. He wasn't thinking clearly, that's for darn sure. And dementia could be the major cause of that.
Yeah, and how did he get the gun? That's the thing that struck me as so strange. Well, as I said, a GoFundMe.
Colorado.
Well, that's a good point, but still, he shouldn't have had it. Look, a GoFundMe campaign, I said, was set up, raised more than $12,000. And to give you an idea of who Ricardo is, his family members have said he's an all-time winner, not just a maintenance man. He loved everybody. He was loved by everybody. And anytime a resident had a problem with their home, whether it was changing a light bulb or something or not working, he was there for them. He was a remarkable guy. So we're going to leave it on that when we think about this case and the tragedy that ultimately resulted. So we'll wait to see what happens with this 95-year-old man. I have to say, I think probably the oldest defendant I've heard so far that we've covered here on Law and Crime Report. But Gene, Katie, I appreciate you both taking the time to break down all these cases with me. Thank you so much. Everyone out there, thanks for joining us here on Law and Crime Report. We're always here Monday through Friday, 12 p.m. Eastern. Until next time, We will see you, and have a great weekend. Be safe.